Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Okay, we're back in Murray, Kentucky with attorney Jeff Roberts, and today we're going to return to the topic of Social Security disability insurance. Jeff, welcome back, guy.
Hey, Jim, how are you?
Doing well. So today let's talk about a few issues, and your practice is made up of Social Security disability actions, it's made up of workers' comp benefits claims, and it's made up of personal injury claims. So you've really been in the injury side of it for almost a full 30 years now. But when it comes to Social Security disability, I mean, that's a complicated area because of the bureaucracy involved. And one of the issues that we got to talk about is an insured status requirement. And so let's break those out.
Yeah, Social Security is a big part of my practice. I do quite a bit of Social Security work and have since '92 when I first started practicing law here in Murray. And, Social Security administers two types of disability programs: Social Security disability insurance, which is commonly referred to or abbreviated as SSDI or just SSD, Social Security disability, and then they administer SSI, which is Supplemental Security Income. And the disability decision is the same for both. If you're disabled for one program, you're disabled for the other program. It's the non-disability aspect that differs between the two. For Social Security disability or SSDI cases, you have to meet the insured status requirements to be eligible to receive those disability benefits. The SSDI insured status, basically that just means you have worked enough and paid enough into the Social Security system to be eligible to receive disability benefits. A lot of times you may hear somebody mention quarters of coverage or something of that nature. That's essentially what they're talking about, or what that's kind of referring to. Every time you work, they break it up into quarters over the year, and you earn so much, and then you can earn 4 quarters of coverage every year. And I kind of liken it to somewhat in insurance from the standpoint, like when you purchase your car insurance, if you pay a year's premium on April 15th, 2022, then on or before April 15th, 2023, you've got to pay another premium, or you lose your car insurance on that date. And it's the same with Social Security disability. When you work and you pay into the system, you're paying that quote-unquote premium, so to speak, for that disability, Social Security disability insurance. And then if you stop working, stop paying in, then after a period of time, you will lose the insured status requirements. And if you become disabled after that date, you don't get Social Security disability because you don't meet those insured status requirements. As a general rule, basically, if you've worked and paid in a decent amount every year from that, you got 5 years before you lose that.
Right.
And normally that's what I'll say. If somebody stops working in November of 2018, they'll be insured through December of 2023 or something of that nature. So you got a pretty good while there that you would maintain. Where it comes into a problem is people who have a sporadic work history.
Right. Then they worked for cash versus a W-2.
Yeah, exactly. And that's the other one that comes into big play in that setting as well. But if you have a sporadic work history where you work 3 or 4 months out of the year and then you're off, and then the next year you do the same thing and then maybe not work for a year or something, then you may not be getting all 4 quarters every year, and you may lose that insured status requirements much sooner in that setting. And it's if you are working steadily but you're not paying the taxes on those earnings, then you because you're getting paid under the table, which you should not do because you're supposed to pay your taxes from there. But if you're getting paid cash and you're not reporting that income on your taxes, and not paying the FICA tax on that, then you're not getting the benefit of that for the Social Security disability insured status requirements. What I've seen here locally, because we're a rural area of Kentucky, is a husband, wife both work on the farm, the family farm, and they only pay taxes under one of the income. So, only the husband is paying the FICA tax or whatever off that farm income, and the wife, even though she may be working on the farm, isn't paying in that Social Security FICA tax in that setting. I've seen that in the past from that standpoint.
So playing that out, if something were to happen to her and she needs to file for disability, the system could say, hey, wait a minute, we don't have enough of those credits built up, you're ineligible.
Right, exactly. So it can affect the insured status, even though they may have been working as hard as anybody's been working. But if it wasn't paid in under in the right way on the tax forms, that could affect their ability to receive disability if they become disabled. And frankly, unfortunately, most people are of the mentality it's never going to happen to me.
Until it does.
Until it does, exactly. And until I started doing this for a living, I was of that mentality. When I was 18, I was invincible. And that's just, after representing so many people over the last 29 years, I realized next week I could be in that situation. Yeah. So,
and again, to clarify, we're talking about Social Security disability insurance. We're not talking about Social Security you get at retirement age, and we're not talking about the SSI, which is the Supplemental Security Income. This is strictly the SSDI benefits that we're talking about.
Yeah, all I'm talking about right now is Social Security disability, and you've got to have that insured status requirements. Retirement benefits,
something different.
It's different. It goes off of quarters of coverage to some extent there as well. But SSI is completely different. SSI is a financial or a needs-based program, so you have to have the financial need to get that benefit. So if and they look at the household income. So if you're disabled and you don't meet the insured status requirements, and you're the only adult in the household, the only person that was working or able to work in the household, then you probably will qualify for SSI based on financial need, depending on what other assets you may have. But if you're a spouse and your spouse is working and earning $20,000 a year, that's going to knock you out of eligibility if you don't qualify for Social Security disability because of the insured status requirements. You're probably not going to have the financial need to get SSI. And those decisions are made before they get to are you disabled or not.
Right.
So even if you are disabled, they don't even reach that determination on that.
Wow.
So, Social Security disability is are you working now? And if you're working, earning or performing substantial gainful activity, I should say. If you're doing substantial gainful activity, you don't get Social Security disability benefits or SSI benefits for that matter. And the next determination on Social Security disability is, do you have the financial, or do you meet the insured status requirements? And so if they say no, they don't go any further.
Right, yeah. Game over at that point.
Exactly.
And that's a shame for a lot of people. I know typically when we tee up an episode on Social Security, people thinking, oh, okay, that's retirement. No. These are separate, distinct programs. And so, we really want to be explicit when we're talking about this. Now, interestingly enough, in previous podcast episodes, and I believe even on your website, we've talked about you can still potentially qualify for Social Security disability insurance benefits, even if you're filing a workers' compensation claim, or even if you've been in a car wreck. Sometimes those all kind of work together.
Correct.
Some offset, but sometimes they can you can file all three together.
Yeah, there can be interplay between them, but having a work-related injury and receiving workers' compensation benefits does not automatically knock you out of eligibility for Social Security disability benefits, or reduce. It can reduce what you receive, and depending on certain factors, could completely reduce it or eliminate it. Rare that occurs, but it does occur at times. But it doesn't prevent you from pursuing the claim. The same with a car wreck. Frankly, a car wreck or a work injury are frequently what triggers someone being disabled.
Right.
No, there are other types of disabilities besides injuries, chronic illnesses, diseases, etc., that can come into play that make someone disabled. But an injury occurring from either car wreck, work injury, something of that nature, a lot of times is the triggering factor to cause someone to no longer be able to work.
Right. And that's one of the things I know for sure that we've talked about in the past is because you're able to handle all three areas, it does sometimes benefit you when you're handling the case because you know, okay, what's been filed over here, you've got the medical records, you've got the documentation, you know the case. So as you're pursuing maybe a Social Security claim on this side, a comp claim on that side, or a car wreck claim, motorcycle claim, for instance, you kind of have all the information in front of you. You know how to really kind of negotiate those settlements because, at times, like you said, in workers' comp and Social Security disability insurance, there's an offset there, and you want to be sure how you word the settlements, right?
Exactly, and
Legally, how you word the settlements.
correct, exactly, and you can word it in certain ways that maximize the recovery for the injured party, which is what the attorney obviously wants to do. As long as they do it within the bounds of the law, which obviously the attorney wants to do as well. So having one attorney handling those different cases can be very, very beneficial because they are familiar. They know, okay, this is what the status of the Social Security claim is, and even though it may not have been granted based on my years of experience, I've got a good idea on whether I think it's going to be granted or not. And so if I resolve the workers' compensation claim before the Social Security case is resolved, I know to word that agreement to try to maximize the benefits under the Social Security claim. Whereas if I wasn't handling the Social Security case, I may not know that aspect of it. And then the same with if it's a car wreck, there's not as much impact on the Social Security disability, but the benefit to the worker is you're dealing with one attorney who's handling it all, and you're only incurring one set of costs for incurring the records and things. Because if I get the records in the workers' comp claim, I can use those in the Social Security case without having to order them a second time.
Right.
From that standpoint, or if the work injury was a car wreck, so we've got all three cases, I use them in all three claims at one. So it cuts the litigation expenses down to the client when you do that.
Right, and that makes it's just kind of surprising that a lot of injury firms, if you want to just call them injury firms in general, may not handle Social Security or workers' comp. They're more interested in the motor vehicle accidents, such as the motorcycle, the car, the tractor-trailer collision, rather than actually a workers' comp issue or Social Security. So they may have to bring in another law firm or another attorney to handle that side of it, whereas here at your office, you kind of handle all three. And
Correct.
I'm just trying to tie that up
Yeah,
and put a nice bow on it.
and that's absolutely true. There are some firms that don't handle workers' compensation claims, don't handle Social Security cases for whatever reason. There can be a variety of reasons why they may not want to do that from that standpoint. It just like I don't do criminal defense. I don't do divorces. But I enjoy what I do from that standpoint in the workers' comp, Social Security, and general personal injury. I enjoy doing all of those, and they all interplay or can interplay in certain cases. And I found it's just been beneficial for my clients for me to be able to handle all of those for them from that standpoint. Doesn't mean that I don't, that there are a lot of attorneys who will do a car wreck case that won't handle the Social Security or the workers' comp, and they may reach out to me to handle that on behalf of their client. From that standpoint, and we coordinate and we make sure we do it to the best, to where it's the best for the client in that situation when that occurs. So it can be multiple firms can be doing it and coordinate with each other. You just don't have to worry about the coordination aspect of it if it's one firm that's handling it.
You got a question about this? Which firm do I call? Things like that. It's easier to have sometimes one person to just say, "Hey, okay, what's going on?"
Right. Exactly.
That makes sense. Go ahead. I'm sorry.
No, I was going to say, and that's the, and it gets back to the disability aspect of it, and And that's when you're talking about Social Security disability, that's the other side of it. You've got to meet the insured status requirements to get that, but then you also have to be disabled, as that term is defined by the Social Security Administration, to get those benefits. And there's a couple of different ways to be successful in a Social Security disability claim. One is by meeting what's called the listings of impairment. The listings of impairment is basically a set of regulations that say if you have this medical condition with these complications, you're automatically considered disabled. They don't have to go any further. Yes, you've got this condition and you've got these complications. Significant kidney disease and on dialysis. Certain cancers that are not with complications are not treatable. Type cancers and a variety of other different medical issues that can meet what's called the listings of impairment. Frankly, you don't want to meet the listings of impairment because those are very, very, very significant, severe problems, usually expected to result in death in the not too distant future to meet the listings of impairment. But then the other way is basically to establish that you can't work, and that there's a system where Social Security has set up, and a variety of things come into play in making that determination. They're going to look at what your educational background is. Someone who has an 8th grade education is treated differently than someone who has a college education, and rightfully so. They're going to look at your age. A 60-year-old is treated differently than a 25-year-old, and rightfully so, from that standpoint.
And let's come back to that. Let's hit the education part first. So you said someone with a high school education versus someone that's got an advanced degree, a college graduate, maybe a PhD. Why is that different?
Because the job market open to that individual. A person who has less than a high school education, they don't even have a high school degree, more likely is going to have to do a more physically demanding job. Does that mean everyone that doesn't have a high school degree is doing a physically demanding job? No, but statistically speaking, those individuals are going to be doing a much more physically demanding job, and so it's going to take less, so to speak, for them to be disabled because they're not. They may not have the ability and the education to do computer work and do a sit-down job because they don't know how to type and they don't know how to operate a computer and do that at least significantly and sufficiently to hold a job doing that type of thing.
So that threshold's a little bit lower in that case.
You're right. So they still, if they can lift 50 pounds, they're not going to be disabled either because there's a lot of jobs that they can still physically do from there. So all of these different things interplay with each other. So, someone with a college degree or a professional degree above that can still be disabled. It's going to be by other factors. Education is not one of the factors that's contributing to their disability. Let's put it that way.
They may have other jobs available to them, just
Correct.
maybe not that specific job.
Exactly. They're much more likely to be able to do a sedentary type of job from that standpoint. So, the education is one of the factors they look at. Age.
Yeah, I wanted to come back to age. You said an injured 22-year-old versus an injured 60-year-old. There's a difference there in how they're treated by the system. Let's
Correct. Now, the system basically treats 18 to 49 the same. The first change in the regulations is at age 50. Excuse me. And another change comes in at age 55 from that standpoint. And it's just a big part of that is adaptability from that standpoint. A 60-year-old is in employability to some extent, even though Social Security won't tell you that. But a 60-year-old is not expected to be able that's done factory work their entire life, is not expected to be able to adapt to be able to go into do something they've never done before, or frankly get hired to do that when there's a 22-year-old that that's sitting there and is going to be trainable. And if they get trained, they get 40 years worth of work out of that person versus 4 years worth of work out of the 60-year-old or 62-year-old. And, will the employer tell you that? No. Will statistics tell you that? Yes, despite you can't have age discrimination and all of those things. But, facts are,
There's a practical reality.
There's a practical reality, and these regulations have been in for a long, long time. From that, and then obviously the biggest issue is, what's your physical abilities, physical and mental abilities, I should say, to do work activities, and that comes back to what's the nature of your disabilities. And I talked about the listings of impairment earlier, and the listings of impairment tend to focus in on one condition. You can meet the listings of impairment or equal the listings of impairment instead of meeting the listings of impairment. But as a general rule, they're going to look at, okay, do you have kidney disease with these complications? Do you have cancer with this type of cancer with these complications? And they're looking at focusing on that. And most people that I represent have more than one reason why they're not working. Right. They may have one primary reason, or one reason that was the straw that broke the camel's back, so to speak, that they had these other issues they were able to accommodate and still work around. But then this last work injury was basically what they couldn't overcome and get back into it. But all of them interplay in preventing the person from going back to work. And so and the judge is supposed to look at, and Social Security Administration is supposed to look at how all of the different conditions interplay with each other and determine what the person's residual functional capacity is, which is basically what work limitations are placed on that individual because of their different physical and mental disabilities or conditions.
And really, that's a big part of what you're doing as an attorney who'd be representing a client in one of these cases, one of these SSDI claims, is you're trying to prove, hey, judge, here's what we're dealing with now. Here's what has happened. Here's what they used to do, and here's what they're capable of doing now and maybe in the near-term future. And so you're putting that case together. This is not something that an inexperienced attorney really needs to be handling. This is someone, you're in your 29th year, almost 30th year of practice now. You've handled these for many, many years, and you kind of understand what the judges are looking for. You understand what to look for in building that case. Not that you necessarily do it any better. We can't say that, but you've got experience. You know what you're doing.
Yes, I've done it for 29 years, and I at least think I know what to ask the doctors, and that's where it comes in, because I have clients come in to me and they say, my doctor told me I'm disabled, and they said they put it in their office note that Joe Smith is disabled, and I'm just saying Joe Smith. So if there's a Joe Smith out there, I'm not really referring
generic
to you.
Joe Smith.
Yeah, is disabled, and so I don't know why Social Security didn't grant my disability, and they don't understand what the judges and what Social Security Administration are looking for, what they need.
They're required to look
for. What they need to grant it. It's not that Social Security doesn't want to grant it. Sometimes I think that may be the case, but they would never admit it. But it's not that they really want to deny somebody, but there are certain things they've got to have before they can grant it. And a doctor just saying that John Doe, Joe Smith, whatever, is disabled is never, ever going to satisfy the Social Security Administration. And I can tell you, if you go to a judge on your Social Security disability case and the doctor said that, the judge's decision is most likely going to have some sort of language along the fact that while Dr. So-and-so said John Smith is disabled, that is a decision left to the Commissioner of the Social Security Administration, not a doctor's decision. It's not a medical determination, it's a vocational determination. And so I pay that no weight whatsoever. You're going to get some language to that effect in there, and that doesn't help out at all in getting your case granted. There's what the doctors have to address is much more nuanced, much more detailed as well than that, and that's where the attorney comes. Having an attorney helps you because the attorney knows what to ask the doctors. May have forms that they can use to make it even easier on the doctor to address what needs to be addressed. And it varies, if the person has a herniated disc in their low back, there's a certain set of questions that you're going to ask. If it's in their neck, there's a different set of questions.
It's a different condition.
Yeah, it's a different condition. It's a different set of questions that need to be asked. If it's a mental health issue, it's a completely different set. If it's a liver condition or internal organ type things, then there's different things that you have to address, and it varies according to the medical problems that the client has on what you ask the doctor. And it, frankly, a lot of times I'll ask, the orthopedic doctor treating my client this, and it may be the psychologist. I'll ask a different variety of questions, and if there's a gastroenterologist involved, I'll ask them a different type of questions, and then basically present all of that in a cohesive format for the judge.
You're building the file. You're building the evidence to make it an easy decision for the judge, or at least an easier decision to say, Judge, look, I mean, there's enough here to say this, and on that point, why we believe this person should be granted disability.
Exactly, and it may be that, their low back condition says that they can do some sedentary type work. They just can't do heavy lifting, but they can do a sit down job, not lifting greater than 10 pounds. So they can do a sedentary job, but then the mental health conditions prohibit them from working around the public.
And by the way, he's 58 years old, and all he's ever done is farm work.
Exactly.
So, again, you're able to build that case together by looking at all those different factors.
Right, and all of those factors come into play, and then it needs to be cohesively presented to the judge or the decision maker, so that they can say, yeah, this is what the regs say, this is what they presented, and so they can't do this because of this condition, they can't do this because of this condition, and there's nothing left for them to be able to do, and the person is disabled and is entitled to disability benefits. That's where the attorney earns their pay in these cases.
That makes a lot of sense. Jeff, you're down here in Murray, Kentucky, which is in Callaway County. But you don't just handle cases in Callaway County. You have more or less a regional practice, and because of Social Security disability, it's a little bit broader than that, obviously.
It is actually. I handle workers' comp, personal injury cases all over the state of Kentucky. I'm licensed by the Kentucky Bar Association to practice in Kentucky and can practice in all courts in Kentucky. By the Social Security Administration, that's a federal program, nationwide program, and actually the Social Security Administration has licensed me to handle Social Security cases in all 50 states. There, and I handle cases out of Tennessee on a regular basis, just because I'm close to the Tennessee border. But I've handled cases in Florida, Oklahoma, Missouri, Illinois, Indiana, and Alabama. Off the top of my head, are the ones I can remember. I handled cases in all of those states for the Social Security Administration. If you live in Hawaii and want to hire me on your Social Security case, I am more than happy to take that case on. So I can handle Social Security cases outside of Western Kentucky and even outside of the state of Kentucky. That's the only type of case I'll handle outside the state of Kentucky, but I can handle those outside the state of Kentucky.
And so if somebody's listening to this podcast episode and wants to get in touch with you, what's the best way for them to do that?
There's a variety of different ways to get in touch with me. Frankly, the best way to reach me is going to be by phone. You can call my office at 270-753-0053 or use the 800 number, which is 1-800-844-5108. And if you call in during regular business hours, 95% or greater of the time, you're going to reach a live person who's going to answer the phone. That's the reason I say that's the best way to get in touch with me, because you're going to get in touch with a live person there. We have 3 lines that roll over from that. So unless all of us are on the line, somebody's going to pick up that phone call. And then you can also reach me through my website, or you can shoot me an email at jeff@jeffrobertslaw.com. All 3 of those ways are ways to contact me from that standpoint. I do have people just drop in and schedule appointments. As a general rule, I'm probably not going to be able to see you when you drop in from that standpoint, but they will get the information and schedule the appointment for you. So if you happen to be in Murray and want to stop by and set up the appointment, you can do it that way as well, whichever's the easiest way for you to contact me. We try to make it as easy for our clients as it can for them to get in touch with me so that they can talk with me.
And again, as we're just kind of coming out of the COVID pandemic, I mean, there's the option of doing stuff over the phone. There's video calls. All these other options are available. Once you're engaging with a client or a prospective client, always just sit down and kind of talk about the case and try to figure out what the situation is and the best path forward.
Exactly, and that I have clients that I've represented that I've never seen in person. I've seen them on video chats. I've emailed with them. I talked to them a ton of times, but they live in Florida, and I handled their case here, and so and that's one of the things. I like everybody, I wish the pandemic had never hit, but one benefit of the pandemic is the video conferencing aspect of it, and it was probably there before. I just didn't know about it. But with Zoom,
we called it FaceTime, Jeff.
Well, yeah, but I didn't FaceTime either.
Right. But from a legal standpoint, from a practical standpoint, with
Zoom and courts went to doing that with video conference too. Zoom, Microsoft Teams, which was Skype.
Yep.
In doing that, people did that to communicate with each other. In the legal community, it become much more a way of communicating with clients, communicating with defense attorneys, communicating with the court system than it ever was before. From that, and frankly, it's been good because I've been able to see clients that live a long way away from that standpoint and deal with them. I've always been able to represent clients through that may live a distance away through because I've represented a lot of truck drivers who've got hurt in Kentucky, but they live in Colorado or Texas or something, but their claim is out of Kentucky, and I handle their workers' compensation claim, and we do it by email, by mail, by phone. But now being able to actually see the client in a video call on Zoom works very well, and I actually like that because I like to see people when I talk to them, and it makes it a lot more enjoyable for me to actually put a face to the client. And them to put a face to me.
Yeah, and I think that makes a lot of sense. So today's episode dealt with Social Security disability insurance, and we talked really specifically about insured status requirements. And this is a complicated issue. Again, it's a federal government program, which by definition is going to be a complex situation. But Jeff is here to help try to simplify that and make it a little bit easier.
Yes, and I hope you do not need my services for that. But if you do, if you have conditions you think you are disabled and can no longer work, and you want to talk with me, feel free to give me a call. I'll be happy to try to help you if I can.
Jeff, that's a good way to wrap up this episode. I appreciate your time, guy.
Thank you.
Yep. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.